Are we okay to go for the next? Melissa and Kendra are the parties for Taylor Barnes, the Governor's Office of Economic Development.
Yes.
Hard copies of the document we provided in support. The declaration of Mark Roberts, we have a signed version, and we brought those for the committee.
Give it to. So some of you have been before us before, but first of all, let's do some introductions. Let's start with the petitioner.
My name is Angie Schuin. I represent Ms. Barnes and Inkstick Media for the request here. Ms. Barnes is here.
My name's Taylor Barnes. I'm a reporter with Inkstick Media.
Yeah, and I'm Anthony Kay. I also represent Ms. Barnes. Angie and I are colleagues.
Great, thank you. Now to the respondent.
Hello, my name is Todd Jensen. I'm an Assistant Attorney General, and I'm assigned to represent the Governor's Office of Economic Opportunity. And on my left with Cameron Dalton.
Cameron Dalton, I am the Managing Director of Operations for Governor's Office of Economic Opportunity.
And I am Mark Wagner. I represent the third-party intervener, Northrop Grumman Systems Corporation.
Thank you. So we'll start with 20 minutes. You have 20 minutes from the petitioner and then 20 minutes for the respondent. There's time for questions from the committee. And then you each have 5 minutes to sum. So if you're ready to go, we'll just jump right in.
I just have a quick question in terms of procedure. Ms. Barnes and I are going to kind of share the time here. Does she need to be sworn in? I saw the captain being sworn in, so I just wanted to clarify the procedure there.
So swear you in now. Barnes, do you affirm that you will tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Okay. Please
Also,
proceed.
just as so 20 minutes, then 5 minutes, and then 5.
Chair. But also just wanted to point out there are participants online participating remotely from Northrop Grumman as well. Krista Domers, who is legal counsel for Northrop Grumman, is participating remotely. And Lori Nieto is a tax director at Northrop Grumman. They're participating remotely as well.
Thank you. Okay, please proceed.
Thank you. Like I said, my name is Angie Schuin, and I just want to provide a quick outline of the points that we'll make here today in the 20 minutes we have. So first, I want to clarify the scope of the request that's at issue. Inkstick is, Ms. Barnes and Inkstick are seeking the final contract between the Governor's Office and Northrop Grumman, and that's the record that's at issue in this appeal. Next, I want to speak to the specific GRAMA provisions that the Governor's Office relied upon to redact certain portions of the final contract at issue. And then finally, while we think GRAMA speaks directly to the specific record at issue, we want to address Northrop Grumman's claim of confidentiality that seeks to restrict access to the final contract. So regarding the scope of the request, as I mentioned, we just wanted to clarify that the Governor's Office brief mentions private tax records, private employee, specific employee records, and cites to 2 criminal statutes that would prevent disclosure. Our understanding and what we appealed is the final contract, the final economic development agreement between the Governor's Office and Northrop Grumman. So we understand what's being restricted here is attachment A and attachment B to that final contract, which includes employer identification numbers and the projected job growth and salary information, which happens to be the very heart of this agreement. The Governor's Office did not classify the final contract as a private record. We understand that they classified it as a protected record under subsection 305. So to the extent they're attempting to classify it as private, we think they've waived that argument. So moving on, our position, our main argument is that GRAMA speaks specifically to the record at issue here, and does not allow the governor's office to restrict access to final contracts that it enters into with private businesses like Northrop Grumman. I did provide a PowerPoint slide that I think if we wouldn't mind putting up, I just want to put those provisions up on the screen so we have those, because I think the language of those is important. But basically, Utah Code section 63G-2-305, subsection 35 and 83 were the provisions that the governor's office relied upon. What's important to note about those provisions is the end of those provisions specifically state that the sections may not be used to restrict access to a record evidencing a final contract or approval decision. Subsection 83 speaks to this particular circumstance that we're talking about here. One, it says, it calls out the governor's office of economic opportunity, cites to their statutory authority to enter into these specific kinds of contracts, and expressly says that final contracts or approval decisions may not be restricted. We think it's clear that the legislature clearly contemplated this exact situation. This subsection applies to the governor's office and Northrop Grumman and the record that's at issue in this case. The parties here were not in dispute that the record at issue is a final contract. In the chief administrative officer's letter on page 2, the administrator says that the governor's office has provided the final contract to you with some redactions. The governor's office brief, their statement of facts, paragraph 4, references the agreement, the record that's at issue here, and paragraph 7 says that Inkstick requested the EDTIF or Economic Development Agreement. Northrop Grumman's request to intervene in the declaration, Lori Nieto, and I hope I said that right, stated that it entered into a 20-year economic development agreement on January 10th, 2020, and that's paragraph 5. So I don't think there's any dispute that this is a final contract as contemplated by subsection 35 and 83. The arguments that the governor's office makes in their brief related to policy arguments and Utah's unique tax incentive program does nothing to justify departing from the plain language of the statute. We think in drafting these provisions and enacting them, the legislature has already balanced the competing interests at stake, being Northrop Grumman's private interests, commercial information, those kinds of things. They've already balanced that, and subsections 35 and 83 allow the governor's office to withhold lots of information, but under no circumstances may it withhold or restrict access to a final contract. The legislature did recognize in these provisions that the public has an interest in the final contract. The public has a right to know if the governor's office struck a good deal. The public also has a right to know what the deal was. And as audits come out about Northrop Grumman's performance, whether they have amended the contract, changed the agreement, those kinds of things. So we think the legislature struck a balance between those interests and said under no circumstances can a final contract be restricted. Next, I just want to address the claim of confidentiality here in this case. If Northrop Grumman is allowed to claim confidentiality of a final contract, those provisions, 35 and 83, are basically meaningless because by their very nature, the final contracts will contain negotiations and will contain commercial information. So statutory construction says if we have specific provisions that speak to a specific circumstance, we follow that specific circumstance. More general provisions that might conflict don't need to be given effect when we have something that speaks specifically to the issue and the record at issue. But even putting that aside and assuming that Northrop Grumman can claim confidentiality and in so doing restrict access to a final contract, it's our position they haven't established it will suffer economic harm if the contract is disclosed, or that its interest is greater than the public's interest in accessing the document. Regarding Northrop Grumman's claim that it will suffer economic harm, our understanding of attachment B is that it contains the job and salary growth that they promise to provide over the next 20 years. They state that disclosing this information could harm its ability to bid on future projects of the Air Force's ground-based strategic deterrent, the GBSD missile program. But as we talked about in our brief, and as Ms. Barnes is going to elaborate on, there are no future bidding projects. And any attempt at saying there are is very, very speculative. It doesn't constitute actual harm. Ms. Barnes is going to talk a little bit about future bidding projects.
Thank you very much. So this contract, the weapon in question here goes by several different names. It's an intercontinental ballistic missile. Its project name was the ground-based strategic deterrent. It's since been renamed the Sentinel. It's the land-based missile in the United States nuclear weapons arsenal. And Northrop Grumman won this contract in a pretty controversial process because there was no other bidders. It was already a single bid contract. So I was surprised when the governor's office told me that Northrop Grumman would suffer competitive harm if this contract came to light, given that there actually was no competition all along. That's because Northrop Grumman acquired a key provider, a solid fuel rocket engine maker, that led its only competitor for this contractor, Boeing, to drop out of the competition and say it was unfair. So then after the governor's office told me that Northrop Grumman might have future competition for this contract, I approached a spokeswoman for the Air Force and I said, could you please tell me when the next open bidding for the ground-based strategic deterrent, or Sentinel, is? And she responded, Taylor, the Sentinel is being made by Northrop Grumman. They are the prime contractor. This missile is supposed to do its first type flight test next year and reach initial operational capability by 2030. The Air Force doesn't have wiggle room. It's not, deciding amongst multiple contractors to see who's going to make this missile better. And I also just want to state the obvious, that attachment B, I have seen other examples of what attachment B may look like when I've looked into state and local subsidies to defense contractors in other states. And I have a hard time imagining how this, quote, provides a competitor with useful information when it includes, a list of jobs, the number of jobs they're supposed to create, and the minimum wage they need to provide. If Boeing knows they can make an intercontinental ballistic missile for cheaper than Northrop Grumman, they know that because they are engineers and they have made plenty of missiles themselves, not because they looked at attachment B and had a eureka moment and said, oh, wow, Northrop Grumman is having 500 people. Perhaps I could do it with nearly 400 employees.
Thank you, Taylor. The other aspect of this attachment is it includes salary information. And some of the materials we provided in advance of the hearing, Northrop Grumman posts its salary ranges for specific jobs that it posts publicly online. So if you're an engineer and you want to look at how much does Northrop Grumman pay versus some other competitor, you can find out a range of salary that you could get at Northrop Grumman. So that to the extent that posting or disclosing the salary information that they promise to provide in exchange for a tax incentive award, we just have a hard time understanding why they post their salary information online, but yet won't provide it in this contract.
It's confidential.
The second attachment that has been redacted and restricted contains employer identification numbers, and that's the basis that it was restricted. Northrop Grumman has said that these EIN numbers, identifiers, can be used fraudulently or inappropriately. But again, these numbers, they're not the same as Social Security numbers. Most of them are publicly available. If you're an employee, typically on your pay stub, your employer tax EIN identifier is on your pay stub. It's not necessarily true everywhere, but if you can access that information from your employer. As we provided in our brief, Northrop Grumman EIN identifier is in public filings with the SEC. They also publish their EIN identifier online. If you go to investor.northropgrumman.com, you can find employer identification numbers. The last piece we want to talk about, the other showing they have to make with this claim of confidentiality, is that its interest is greater than the public's interest in accessing this information. And again, Ms. Barnes, this is kind of her area of expertise, and she's going to address both the defense contract aspect of what Northrop Grumman does, as well as economic development agreements generally across the nation, as well as here in Utah.
Thank you. So I just want to say that this matter and this contract is a matter of public interest, both at the national level and at the state and local level. So this map that was just up, I saw that it went away. I wanted to address Northrop Grumman as a defense contractor. That'd be great. Can we get the map back up? Thank you. As a defense contractor, Northrop Grumman has to convince the buyer, which is Congress, which has the power of the purse, to buy its weapons. And one powerful way it does so is by claiming it creates jobs in those representatives' districts. This is what that map is about to show you. It's marketing material put out by Northrop Grumman with its intended audience, I believe strongly, as members of Congress and local communities who believe, oh no, should we vote against the defense bill and vote down this intercontinental ballistic missile, we will be out 10,000 jobs. And you can see the map with the dots all over it. And so this EdTIF contract is a tool that we journalists and members of civil society can use to fact check Northrop Grumman's job creation claims. And on the local level, this contract is a matter of public interest for pretty simple reasons, which is that the public deserves to know how their taxpayer funds are being managed. Money is fungible. The $1 that an ordinary taxpayer pays is not different from the $1 that Northrop Grumman doesn't pay in its tax bill. And roads are still built, public services are still paid for. So the public deserves to know, who's getting a tax cut and whether they think it's merited. Additionally, I'm happy to just go on.
Yeah.
The watchdog groups across the country pay a lot of attention to these economic development agreement deals. Like you might remember the attention over Foxconn or the Amazon HQ2 search. And they are frequently do not live up to the promises that come out in headlines and that politicians promise at ribbon cutting ceremonies. And what the governor's office has repeatedly said, which is that we don't give Northrop Grumman the tax cut up front. We only give it to them after we certify they perform, but we don't let the public know that they actually, what the terms of the agreement are. They say that this unique structure will account for all the failures of such economic development agreements. And I believe the public should still know what the terms of the agreement are. And on page 6 of the EdTIF contract, there's one provision that allows Northrop Grumman to change the terms of the contract. It says, quote, the company may request an amendment to the established baseline throughout the term of this agreement. So it suggests to me that the government could even certify that Northrop Grumman is, quote, meeting its terms, the terms that we don't know what they are, but all along it can actually change them. And finally, I want to address the declaration we have from the former Utah state lawmaker, Mark Roberts. Really just to say, don't just take my word for this as a journalist. These economic development subsidies are of great public interest, both at the local level and the national level. And that's why former Representative Roberts told us in a declaration, quote, economic development contracts are often seen as a burden to communities and a misuse of taxpayer money, as they often involve the allocation of public resources such as tax incentives or grants to private businesses. He added, The practice of offering tax incentives to businesses can create a race to the bottom, with cities and states competing against each other to offer the most generous deals. That's why Representative Roberts sponsored a bill to ban the use of such subsidies in the state of Utah, and his colleagues overwhelmingly agreed with him. And this bill was to join an interstate compact, basically to sort of call quits in the race to the bottom, sort of an end to the arms race in economic development subsidies. And his colleagues in the State House voted to support it in a 63-3 vote. So with that vote, Utah's own lawmakers said they cared about such deals and wished they could phase them out.
So I just wanted to wrap up. I know our time is getting slim here. We think GRAMA speaks specifically to the circumstance here. A contract between the governor's office and a private entity like Northrop Grumman cannot be restricted. We're asking the committee to fulfill the legislature's intent by applying the plain language of these subsections 35 and 83 and require the governor's office to disclose an unredacted final contract between it and Northrop Grumman.
One more point to make. They didn't address the statute issue in their brief.
All right,
You want to
we'll just pause.
say that now? You want to say that now, that they don't dispute, they don't try to dispute the statute. You want to say that now?
Tony reminded me, we just want to, the governor's office has not disputed that these provisions of the statute apply. Subsections 35 and 83 of GRAMA.
Yeah, I mean, and if I can just like clarify, it's not addressed anywhere in their brief. So our brief in explaining this on appeal is that, you know, this is a final contract. It's evidence of the final contract. It's not negotiations or anything like that. And that's why it should be, that's the main reason it should be disclosed. And there was nothing, not a word said in the government's opposing brief about that argument or that statutory provision. So our argument there would be that it's waived. Like they can't raise that issue at this point. They've effectively conceded it.
Thank you. Any questions for the petitioner?
I have a question. Part of your argument is that it seems to be that this information is available elsewhere. So,
EINs?
yeah.
Yeah,
the
so-
EIN. So what specifically is it that you're looking for that you don't have?
Well, the main argument is that you can't restrict. GRAMA says you can't restrict a final contract. It's being restricted. So there's kind of a broader, you can't restrict it. So, but the attachment B specifically is the heart of the agreement. What did Northrop Grumman promise to provide over 20 years in exchange for almost 60 million in tax incentives? That's completely redacted.
Okay, so it's really Exhibit B that you're interested in. And that's going to be the markers for whether or not they get a tax rebate or whatever it's called.
It's the benchmarks, right? It's essentially the benchmarks that they're supposed to meet over 20 years. And we're not sure how it's framed or laid out, but it's a chart. And this is the core of any of these. They're called EdTIF agreements. The EIN that's another exhibit. It's not, obviously not that important to us, but it just, the fact that it was redacted, we don't really understand because that information is generally considered public. I mean, if you search, like, there's nothing confidential about an EIN number as opposed to a social security number, and to try to conflate those two into one thing is just misleading.
Okay, but that really helps because I kept looking at this, but that's very good. Thank you.
Any other questions? Okay, we'll go to the respondent.
Ken, anyone testifying will swear them in now before they.
Take questions, I can be sworn in now if you'd like.
Yeah.
And online, we have Lori Nieto online, also tax director from Northrop Grumman.
So let's start with Cameron Galt, right?
Correct.
Hey, Cameron, do you confirm that you will tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Who's online?
Lori Nieto.
Lori Nieto, can you hear me?
Oh, she can't. Hold on, let me get rid of this.
Yeah, we don't want that to happen. Lori, can you hear me?
Promoted to apprentice.
Krista Domers is also legal counsel for Northrop Grumman. She may need to be as a panelist as well.
I
Lori.
can. This is Lori Nanta.
Okay, can you hear me?
Yes,
Do you affirm that you will tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
yes,
And then is it Krista?
Yeah.
What is your last name?
Dommers, Dommers.
Thank you. So do you affirm that you will tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
I will.
Thank you.
Well, to start with, the EdTIF agreement that we're talking about today deals with taxes. If we were to conduct a poll of everybody in this room, who likes to pay taxes, raise your hand. None of us would raise our hands. None of us like to pay taxes. We don't want to pay more than we have to. And everyone in this room, their tax records are protected by law. It's a criminal violation if those tax records are disclosed. It's Class A misdemeanor. Similarly, employment payroll records are protected under state law. It's a Class C misdemeanor to release that information. The Governor's Office of Economic Opportunity, the Utah State Tax Commission, and the Department of Workforce Services share the responsibility to administer these EdTIF agreements. GOEO, the Governor's Office of Economic Opportunity, has entered into strict memoranda of understanding with these different state agencies to protect this information. There are specific statutes outside of grandma that protect these records from disclosure. Counsel for Inkstick claims that GOEO failed to talk about whether or not this final contract is subject to public disclosure. We recognize it's a final contract subject to public disclosure, but we spent 20 pages talking about the reasons why these specific sections that are redacted are not subject to public disclosure. And I won't reread all 20 pages of our responding brief, but we start out saying, in general, a record is public unless otherwise provided by statute. And final contract, as a matter of law, is a public record. However, there's plenty of case law and state records decisions to show that a public record can be redacted if it contains private or protected or confidential information. So that's what we're talking about. That's what we spent 20 pages talking about. So there's been no waiver. We readily acknowledge that this is a final contract, and the final contract was provided to them with certain sections of it that are redacted. Under Utah law, we are required to redact employment identification numbers, tax ID numbers. We cited to it in our memo. I'll read it to you. We shall redact or remove any name, address, social security number, or taxpayer identification number. That's right from the statute, Utah Code 59-1, 403.1, subsection 2B. GOEO complied with the law. In providing this contract, we complied with that specific state law that requires us to redact the tax identification numbers. The argument that we have waived a statutory requirement is ridiculous. We can't waive a statutory requirement. We're required to redact that information. That's exactly what we did. We removed it in accordance with the statute. It, to me, is a no-brainer. They're asking for tax ID numbers. No, it's a class A misdemeanor. We're not going to provide that unless a court orders it. We're required by statute to remove that information. That's what we did. We gave them the contract. They wanted the final contract. We gave it to them, but we redacted that information. It's a ridiculous argument. Second, we come to the attachment B or exhibit B. Again, the entire contract was provided except for portions that are protected. The state legislature, recognizing the commercially sensitive information that companies will provide to the governor's office, created exemptions under the grandma law. They're right in there. They cited to them in their brief, and we make mention to them as well. Under section 35, there's two parts to it. if the company or the person that's involved in the contract is going to suffer injury or harm by the release of sensitive economic information, then they have a basis to have that information redacted from whatever the record is, if it's a contract or whatever the record is. The second part is that the governor's office has the right to redact information if it's going to hurt the governor's office ability to negotiate or to remain competitive. And we can use Inkstick Media's map. It's the Northrop Grumman map. It shows the United States and all the other states in the US that have offices from Northrop Grumman in them. The state of Utah is competing with all of those other states. That's a great exhibit. I love it. I mean, we could put it up again, but that shows how the state of Utah is competing with all these other states to get Northrop Grumman's business. And all of the job listings here in the state of Utah for Northrop Grumman, they're going to pay over $100,000 to employees to come here and work. That's another great exhibit. We love that. We want good jobs, high-paying jobs to come here to the state of Utah. That is the responsibility of the Governor's Office of Economic Opportunity, and they're very good at it. That's why the state of Utah leads the nation in economic growth and strength. Coming out of COVID, a lot of states in the United States were suffering. Utah was number one. We were number one in the whole country for economic recovery. We have a great state, or business-friendly state, and that's another part of why this is important to the governor's office. We are concerned that if Northrop Grumman is required to agree to the disclosure of attachment B, which contains their competitive business strategy for hiring over the next few years, their competitors would love to have that information. That is not public interest information. That is competitive business strategy. And also, it's protected by statute. The governor's office shares this information, as I already stated, with the Department of Workforce Services and with the Utah State Tax Commission, because we have to verify that Northrop Grumman has actually hired the employees and actually paid them the salary. And we have to verify that Northrop Grumman has paid their taxes. All of that has to occur before Northrop Grumman can qualify to get a tax rebate. So, and that's, again, that's private tax and employment information. That is not subject to public disclosure. It's mentioned in an exhibit to the contract, which is a public document, but that portion of the contract is not subject to public disclosure. Never has been. This is the first time the governor's office has been before this committee on this issue. Nobody's questioned it before. So there are several concerns there from the governor's office point of view of having this information unredacted and subject to public disclosure. Cameron Dalton, who is with the governor's office of economic opportunity, is managing director of operations, can speak to all those concerns. If you want to hear from him, we can do that. We'll allow Northrop Grumman to talk about the competitive injury that they would suffer if the sensitive business strategic information about their plans to hire people was released. We'll allow them, they have their time to do that. So let's talk about a few other things. The governor's office hasn't restricted access to the final agreement. We've given it to them, but there are redactions as required by state law. The specific statutory requirements of other statutes override this general rule that public records are subject to public disclosure. Nobody's going to argue that we're an open, free, democratic government here and the public records should be subject to disclosure, but there are exceptions. And these exceptions have been recognized specifically by the legislature for the governor's office of economic opportunity in exactly this type of situation. When Inkstick Media talks about wanting to protect the public interest and concern that Northrop Grumman may or may not be performing their obligations, again, all of us in this room, we all have to pay taxes. Every business should pay how much taxes they owe. Every person in this room should pay how much taxes they should owe. However, that doesn't mean that your tax information should be subject to disclosure publicly. And there are laws protecting our tax information in that regard. Utah only gives tax rebates to company based on post performance, meaning they have to hire the people, pay them, and then the company has to pay their taxes to the state of Utah. After all of that's been done, then the governor's office works with the other state agencies to verify that that's been completed. None of that is subject to public disclosure, just like none of your taxes are subject to public disclosure. I could question whether any business in Utah is actually paying the taxes they're supposed to, but I can submit all the grammar requests I want. And I'll never be able to see that performance tax information because it's protected. It's private information, private confidential. In the chief administrative officer's letter in response, the final determination from GOEO, we noted that. So like on the second to the last page of the last page, it says right there, employment and tax information, which is what's in attachment B, is private and confidential, not subject to public disclosure. We don't have it because Northrop Grumman at the time hasn't submitted it yet to ask for a tax rebate. But even if we did have it, it wouldn't be disclosed. It's protected by law. So again, this argument that we've never raised that, it's nonsense. It's in writing. It's included as an exhibit. Repeatedly, we see in Inkstick's brief, we see comparisons to other states in the country. Other states do it this way. We don't care. Utah is good at what they do. That's why our state leads the country economically. We don't care how other states operate their economic tax incentive programs. Why? Well, because some of them do a very poor job of it. And it's not fair to compare the state of Utah to those other states. They have different laws, they have different rules. Maybe they release some of this information in other states. Great. Good luck negotiating with companies that want to keep that sensitive commercial information private and not subject to public disclosure. That is an important competitive advantage for the state of Utah. It's important for the state of Utah to maintain that. The legislature in subsection 35 of the protected records portion of GRAMA recognizes that. The legislature has given GOEO this specific exemption for this very reason. In addition to the other statutes outside of GRAMA that protect employment records and tax records, which is what is shared with these other agencies in attachment B or exhibit B of the contract. As the committee considers these issues, you've done this hundreds of times. Generally, a record is public and subject to disclosure unless there's some reason, a statute or something. We have several statutes which we have cited to. So we don't even have to get to the balancing the public interests arguments which come later because we have separate statutes. The employment records, employee numbers that are going to be counted under attachment B are private under 35A-4312. Utah State Tax Commission records about employee payroll tax records, employee numbers. This is information that is shared confidentially between the government agencies under memorandum of understanding. It is private under section 59-1, 403-1. We have the specific exemption in GRAMA for GOEO. That is under 63G2305, subsection 35 that we've been talking about. And there's two parts to that. One is part for Northrop Grumman talking about their economic injury that they would suffer if this information is disclosed. Then we have the separate protections allowed by the confidentiality agreement. That is part of GRAMA. Inkstick cannot ignore the section of GRAMA that allows for a confidentiality agreement to protect trade secrets, competitive information, strategic business information. You cannot ignore one part of the statute and only emphasize the other. They work together. So the confidentiality agreement also is a separate reason to protect this information from disclosure. It is patently unfair for a company to come to Utah in 2018, share confidential information for 5 years under the plain reading of the statute, and then also under a confidentiality agreement to then ask the committee to ignore that confidentiality agreement and the contractual agreement that the governor's office has with Northrop Grumman to then order the release of this sensitive commercial information. It's changing the rules in the middle of the game. And that would harm the state of Utah's ability to get future companies to come to the state of Utah and share this necessary commercial information. It would impair the ability of the office to operate. And it puts us at a competitive disadvantage to other states in the country that don't do as good a job, frankly, protecting private commercial information. The question I think that's really before, these are the questions that I think are really before the committee. Can portions of a government record be redacted for the reasons we've stated? Economic sensitivity, confidentiality, tax records. Yes, obviously they can. We have specific statutes on those points directing that they are to be redacted. And GOEO has complied with that by redacting them. The last point I'll mention is competitors of Northrop Grumman watch this kind of information. They watch public proceedings, they look at public records like this. They have employees hired to look at this information. I know this personally as a government attorney because I've seen records requests from competitors of businesses asking for this type of information. And it's a public record that has to be disclosed unless there are portions of it that are protected or private. So we've done that. We've done that with other government records requests. As a government attorney, I've reviewed other requests for sensitive information and we've redacted things. Competitors look at it. Not only business competitors, but Russia and China are probably watching very closely what Northrop Grumman is doing. I guarantee they are. So it's not just a national concern or a state concern, but internationally, this is a concern. There are some misleading statements that have been proffered, which I also want to correct. The program that Northrop Grumman is working under right now is the initial phase 1 of the nuclear arsenal updating process for the country. It's phase 1. There will be future phases. There will be future competition. So it is inaccurate and misleading to state that there is no competition. Obviously there is. And there are competitors of Northrop Grumman that are competing for employees. It's hard to find qualified employees in some of these specialized areas of aerospace. Northrop Grumman can speak to that better, so I'll only mention that briefly. But I bring it up because the state of Utah is very conscious of the economically sensitive information that is shared with the governor's office under the exception to GRAMA and under the confidentiality agreement. We do not want to jeopardize our relationships with other businesses that we want to attract to Utah to bring good, high-paying jobs to the state of Utah and improve our economy. And if this type of information is ordered to be disclosed, that jeopardizes the governor's office ability to operate and to do what they're supposed to do, sharing confidential information and verifying it with the tax commission and with Department of Workforce Services. And it will put Utah at a competitive disadvantage to other states. That's all I have for you. The time goes to Northrop Grumman, is that correct?
Thank you. I appreciate it. I'd like to make at least 3 points as briefly or as quickly as I can. And that the first of those is that Northrop Grumman did in fact rely on the confidentiality provisions and protections under Utah law in deciding to come to Utah to even apply for the economic incentives that were potentially available. And certainly in actually making the decision to then come to Utah and to include what all of this was part of its larger bid to the U.S. Air Force and to this is the information, the ability, the stuff that goes into the bidding process, the information that they both developed and relied on and provided to the state of Utah is stuff that is part of a bigger picture that frankly, it decided to provide to the state of Utah because of these confidentiality provisions. And that means that's part of why they decided to provide their business to the state of Utah, to create the jobs here within the state of Utah, and to invest in the infrastructure here, to hire other businesses and subcontractors here. It's a reality that Utah is a well-run state economically. And it's also a reality that it is by number of people and by tax revenue base is smaller than and would have a hard time competing with on an purely economic basis, states like California, Florida, Arizona, states that just frankly have a lot more to offer. And they have economic development programs also. They do offer incentives that frankly are financially more generous than what Utah has to offer, and in some instances easier to satisfy requirements of. But Utah can compete at a little bit of a higher level than it otherwise would be able to if it had to rely solely on the generous amount or the generosity of the raw dollars. And that is that Utah can allow for companies to come in and compete and provide economic benefits to the state without jeopardizing as putting at risk their bigger picture as a national corporation and competing on a national basis with other competitors. The government bidding for government defense contracts is extremely competitive. And the information that's used, developed and used by Northrop Grumman in that bidding process, and then by extension, the application process here to the state of Utah is highly confidential business information that it relies on in order to, among other things, to satisfy the contracts it ultimately enters into. And the state requires very, quite a large quantity of this very confidential and sensitive information. Northrop Grumman would frankly, it considers whether or not it has the ability to protect that when it goes to a particular state and looks at applying for incentives. And if it couldn't get those protections, it might make different decisions. So it relied in making the decision to come to Utah again on this confidentiality under Utah law. And again, it's not just under GRAMA, it's under other statutory provisions too, and GRAMA, and the confidentiality non-disclosure agreement entered into at the application process time, and also in connection with the performance under the contract. Because it's not only providing the information at that time, it's also providing potentially lots of sensitive information as it goes through the subsequent audit processes before it can even qualify to receive dime one or rebate one. So with Northrop Grumman actually relying on these provisions to come in years after the fact and essentially pull the rug out from underneath it is going to cause it economic harm. The information in these, and the fact that I'm here arguing about this is itself proof that the company believes it is. It doesn't want to just restrict the information because it doesn't matter. It matters, and it spends money on hiring people like me to try to represent it, to protect its interests. And this, there's a big difference between posting jobs on a website that, by the way, are not 100% for this project, and also, by the way, are not necessarily new hires, but people leave, people quit, they die, they are transferred, new jobs, their rehires have to happen all the time. But in addition to that, they have broad ranges of salary information. That's very different from specific salary information, and it's very different from specific phase-in of jobs, hiring of certain numbers of people in certain years, and the specific amounts that you're going to be paying those people. That's very sensitive information that competitors do look at in determining and trying to figure out what Northrop Grumman's performance strategy is, as well as its bidding strategies. What is it, what is it doing when it's ramping up in this way versus that way? And Northrop Grumman is, in fact, also competing for aerospace engineers, which are not the most common type of applicant out there, qualified ones that you want to have working on sensitive and important stuff. And competitors, again, if you have information about specifically what's being offered to specific numbers of people in a specific category, you can hire people away. That's in fact, an experience that they've had. So, so this is something that, and in the other addenda, actually, I was making a note that the EINs, et cetera, it's not only that, there are also state unemployment identifiers, Secretary of State identifiers, state withholding identifier numbers. All of those things are separately protected. They just happen, it's not just the EINs, which again, and there's quite a number of them. And as is stated in Ms. Nieto's declaration, Northrop Grumman has actually encountered instances when people have attempted to use those, tying them to specific sub-entities and trying as part of a scam or a fraud type of thing. And it's very difficult to see how having that kind of information out there benefits the public or protects the public. And on that note, even though, again, I don't think that we even get to the Grumman balancing test, because again, we already have other statutory provisions. Grumman didn't come in and repeal any other Utah laws. Grumman came in and realized as to things that haven't been specifically dealt with by the legislature, which happens to be a lot of stuff, we want to have a scheme that is in place that provides some order. And so there's a presumption of public access, again, unless it's provided elsewhere in the law, which, by the way, and again, we weren't repealing any criminal laws or any other provisions of Utah code. And so while I don't think we get to the balancing test, I think that nonetheless, that's as additional kind of icing on the cake. There are protections here. I mean, I've talked about what the harm to the company would be. But separately, as far as protecting the public goes, well, there's part of, the EdTIF incentive program here in Utah is structured very differently from how it is in some other states, as mentioned by counsel for GoEO. First off, everything is done post-performance. You can enter into an agreement all you want. That doesn't entitle you to the credits absent the performance. And the performance comes first. So what happens is Northrop Grumman, first of all, pays all its taxes. It brings the jobs in, does that, all those people pay their taxes. That's all in. Now, then, if Northrop Grumman believes that they've satisfied the contractual provisions, they can then apply for specific tax credits, which is a portion, it's 30% of the excess money that was brought into the state of Utah above what would have been brought in if the contract hadn't been entered into. But that incentive, before they get that, and again, after the post-performance, it's subject to audit by GoEO and by up to 6 different independent government agencies here in Utah, which again, it's because of that post-performance audit verification process that Northrop Grumman relies on the confidentiality agreements even more, because it agreed at the beginning of the process that it would grant additional information. So, and thank you for this time. I think I have gone past it.
Thank you. I do have a question. So has tax incentives been given yet? As
No.
They have not met
Not-
that performance.
They have applied for credits, for 30% credits against the first year's performance 2022. Because of the state audit process, it's still undergoing that. And they're hoping to get the credits before the final tax due date so they can actually apply them if they qualify. And they believe they have. They believe they've performed beyond what was promised. The agreement itself, which again was provided, also provides the essential metrics, an unredacted portion, 2,250 jobs. These are, again, net additional jobs and added salary range that's 10% above I can't remember if it's average or median, county average salary.
We will go now back to the petitioner.
Yeah, I think I'm gonna start and just, it seems like we're talking past each other a little bit. And so I just want to again clarify our understanding, at least what we were told from the governor's office, the final contract, our understanding is it doesn't include Northrop Grumman's tax records. They haven't been audited yet. What we are seeking is the projected growth in salary information. We're not seeking specific employee records. To the extent they included that in this contract, that our understanding is that's not what happened. So they didn't, the chief administrator officer didn't cite to or explain that this contract includes specific tax records. I mean, putting aside the employee identification numbers for a minute, they didn't classify these as private because they're actually Northrop Grumman's tax records. We understand this is projected salary information and employee growth. So something they promised to do, but yet has not been done. So I'm not sure how that can be a tax record. And at least as represented to us, that's not what is at issue and what is being redacted and restricted access to. I also want to be clear, they said multiple times that we have the agreement, but we don't have the agreement. We have a summary of what they agreed to at the end of 20 years, but attachment B is the heart of the agreement. What is Northrop Grumman doing over 20 years to get $60 million, almost $60 million in tax incentives? We don't have the agreement. And so to the extent they think they've given the agreement, the heart of it is redacted and restricted. I also want to touch briefly on, obviously there's a position that, the defense industry and Northrop Grumman has a lot of competitors. This deal is done. And in subsections 35 and 83, once the deal is done, the legislature has said, you have to give up the final contract and you can't restrict access to the final contract. Northrop Grumman and the governor's office can control what's in that final contract. Probably they shouldn't be putting things in there like trade secrets and commercial information in a public government contract. We think Graham is very clear that the final contract has to be disclosed. And so to the extent the parties entering into a government contract don't want information out to the public, they shouldn't put it in a public government contract. I'm not sure if Taylor or Tony.
Wait,
Go ahead.
So, I mean, Northrop Grumman says that it relied on Utah law as a basis for entering into this agreement and believing that its final contract would be non-public, but the statute's really clear. And so, I don't see how that can be the case. If the statute says that you can't protect a final contract, then you can't protect a final contract. And they should have known that going in. And, I don't think there's any surprise to them. They may be surprised just because, these sorts of contracts aren't pursued very often, but when they are, they need to be disclosed. And the whole tax, I mean, they're talking about this contract like it includes tax filings and personal, payroll records or individual payroll records or individual employee records. And that's just not the case. And the statutes that are being referenced that are criminal in nature, deal with revealing tax filings and that sort of thing. There's nothing, I don't believe that there's anything on this, and you'll be able to look at it in, in camera, but I don't believe that there's anything on here that, can't be publicly disclosed by virtue of any other state statute. There's certainly no individual personal, individual employee records. And then, what they're talking about, salary information. I mean, literally in the files that we have submitted to you, there are the job postings for the jobs that are the subject of this contract. I mean, they say they are in Utah for the Sentinel project, and they have the salary ranges, and they're not very big salary ranges, nor are they massive salaries either. I mean, they're good salaries. I'm sure it's good for Utah to have salaries like that, but we're not talking about executive salaries or anything like that. We're talking about pretty rank and file, engineers and things like that. Another thing is they say like, well, we don't want people to know how much we're paying, let alone, China. We don't want China or Russia or, our competitors to know how much we're paying our employees. But, any competitive employer like Boeing can pick up the phone if they want to find out what a Northrop Grumman engineer is making, and they can't, for whatever reason, they couldn't find it on the internet. They can pick up the phone, call that engineer and say, hey, we're interested in hiring you. What are you making? We'll pay you more. So none of this is confidential. I'm not sure why we're actually here having a big fight about this. I'm not sure what may, have been included in this that seems, so scary to Northrop Grumman to have to disclose, but I'm pretty sure Northrop Grumman came here knowing that this was a potential, knowing that this would be public information at some point if people pressed the issue, and they took that risk. We're not really any different from all of these other states. Like the other states allow the public to find out how their taxpayer dollars are being spent. And I think it's outrageous, frankly, that, I can't find out, I'm a member of the public and a lawyer. I can't find out how much I'm, spending on this, and I'm paying for opposing counsel to defend a private contractor and the governor's office from disclosing information that I think is of a material public interest, not only because it's how we're spending government dollars, but because of the nature of the project itself. We're spending it on, building missiles for nuclear weapons that aren't really even necessary anymore. I mean, the whole project is arguably a billion, multiple $billion-dollar boondoggle, because, putting nuclear missiles in, the Western United States as part of a defense makes no sense when you have nuclear, submarines that are capable of, keeping us safe and keeping the threat on for Russia and China, whoever else we need to. So I do think this is a matter of strong public interest, and I think it's entirely specious for the government and Northrop Grumman to come here in concert and to say that it's not.
Back to the respondent.
Great, thank you. All right, I want to read from, again, we've heard this misleading statement again, to say that GOEO, the governor's office, never properly classified these records as private or protected or confidential. It's Exhibit C to their memo, okay? I'm going to read directly from the official response from the Chief Administrative Officer. It says on page 4 of Exhibit C, in future years, the compliance department at Go Utah, or the governor's office, will work with the Utah State Tax Commission and Utah Division of Workforce Services to verify that Northrop Grumman meets its post-performance employment and salary benchmark requirements. Those private tax and workforce employment records are not subject to public disclosure. It's right there. I've repeated it again, and they keep saying that we didn't say it. It's right there. I've provided the statutory exceptions or statutory requirements to protect this information. I read them off to you. They can keep claiming that it's not there, that we didn't say it, and we can keep repeating it to you. There's a big difference between a company's confidential business strategy to hire and ramp up their employee workforce and the salaries that they're going to pay over a number of years. There's a big difference between that private, confidential, sensitive business information on strategy versus job postings for an individual job. Northrop Grumman can bring their employees from California or Georgia or Texas to the state of Utah to fill these jobs. And frankly, that's what we want. We want the jobs to be filled here in Utah. We want more money to come into the Utah economy, especially we want our graduates from colleges or universities in engineering or other areas to be hired by Northrop Grumman because it's a great employer. They provide great benefits, good salaries, higher than average salaries, which is a requirement from the governor's office. There's a big difference between individual public job postings, and the competitive business plan of Northrop Grumman to hire and pay salaries. That's the information that is in the redacted portion of the contract. So it's the redaction for an exhibit, attachment B, that we're talking about. The contract has been provided, and on page 1 of the contract, it provides the important critical terms for the performance by Northrop Grumman. The number of jobs, the total amount of the EdTIF award, and the number of years that this plan is going to be in place. And this isn't a one and done deal. They represented that the deal was done. It's a signed contract. That's false. This contract lives on for a number of years. Every single year, over like 20 years, every year they have to perform. This contract is not dead. It's very much alive. They've just recently applied for the first year, and we're cross-checking their numbers. The governor's office is cross-checking and verifying their numbers with the Division of, with the Department of Workforce Services and the Utah State Tax Commission. Those are private confidential tax records. They're not subject to public disclosure. No business's tax records are subject to public disclosure. You can submit all the ground requests you want, but this post-performance information, which is what is referenced in Exhibit C on page 4, is not subject to public disclosure. It never has been. This is the first time we're here because I think everybody recognizes that it's not subject to public disclosure, but Inkstick wants to push the issue, so we're here today. That's all I have. Thank you.
Thank you. Question for the party from the committee. No.
We need to see the exhibit B, I think. Yeah.
So that a motion?
Yes, I move that we review exhibit B.
Just exhibit B?
The contract. Yeah.
We have a motion to review the contract in camera.
Seconded by Nova. Sure.
All in favor of that motion, say aye. Aye. The motion carries unanimously. So do we want to do that now? Or have a short lecture?
Let's do it.
Okay. So the committee's going to go in camera. You have the record with you. I'm assuming the unredacted version. We're going to go in camera. We're going to grab lunch while we're reviewing the record. So
You'll digest the records and lunch at the same time.
okay.
Understood.
Well said.
We're gonna eat the card.
So I would estimate we'd be back about a half hour. So we'll have
Some of those.
call the hearing back into open session. So the committee's reviewed the records in camera, and I think there's a few questions for both parties from the committee.
So I'll just ask, I have a question about the business confidentiality that was attached to. So that one's dated 2018, and just for our clarification, the contract is dated 2020. So would you just kind of explain that process as far as negotiations and the time date difference? How that
Sure.
worked?
I can take it. Either way. Okay. Why don't you start and I'll fill in if needed.
All right. If I get anything wrong, Cameron will correct me. The negotiations process can take a period of time. And then, so that can be part of it. Also, the implementation of the contract is sort of up to the company when they want to start the commencement of it. So that's another thing that plays into it as well. That answers your questions. Anything else to add?
I'll just add, so primarily it's the establishment of a baseline. So these contracts are post-performance is measured against the company's performance prior to engaging in the contract. And so verification goes back and forth, and there are times where they'll provide documentation, we will have questions. And it can take years to work through that, depending on the company's timeline and when and where they want to agree to those numbers. Then, once we do finally agree to that baseline, that's when we proceed with engaging in the contract.
So the business confidentiality, the one that we have dated 2018 is the one that was to be attached to the contract that is dated 2020, that was to be provided
That's
with that particular contract,
Correct.
based on Grandma 309.
That is correct. Yes. There is a second, the second confidentiality agreement was also signed in 2022, but there are ongoing negotiations with Northrop Grumman about other projects.
So does that one that was signed in 2022, does that pertain to this contract or is that separate?
Our argument is that it could apply. I know that Inkstick would argue the contrary, but our argument is it would apply as well. But either way, the 2018 contract confidentiality agreement was signed relative to the specific EdTIF agreement that is before you.
Thank you.
No, but that was one of my questions. You confidentiality agreements, are they made with the company? They're overarching, with all of the business that you're doing, or specific for each contract?
They are overarching, and the EdTIF's incentives associated with this EdTIF contract that you have are, the jobs associated with that are not exclusive to the nuclear arsenal updating project. They can bring in, Northrop Grumman can bring in employees for different projects, but that's not important to the governor's office. What's important is, are they paying the above average salaries? Have they hired a number of employees above or equal to what they have projected? And so it's not limited. There's this false assumption from Inkstick that these are all jobs associated with the nuclear arsenal. That's inaccurate. That's a false assumption.
So how do you know which business confidentiality ties in with what contract, what record that company provides you? That's specific in Grandma, where it talks about glasses on. She'll provide with the record the written claim of business confidentiality. So I'm just wondering, how do you tie that in? Because I didn't see where it said an attachment or the numbers assigned. to
Again,
it. How do
I
you
think
cross-reference?
that's a good question. There's different things under the statute. So providing a claim of business confidentiality, just providing that claim, there are different times when a company can make a claim like that. The negotiation process with Northrop Grumman for the EdTIF agreement that we're looking at today, that began back in 2018. And so when the governor's office received the Grandma request, we immediately reached out to Northrop Grumman to notify them as our duty. We have a confidential relationship with you on these matters. We've received a government records request. Do you want to assert your business confidentiality claim? And at that time, they said, yes, we do. Here's all the reasons. So I hope that answers your question.
Yes, thank you.
No, I think those, that's what I would have asked, so I think that's good.
Can I make a point about the contract since it's up though?
Motion, perhaps.
Yeah.
Well, go ahead.
Okay.
Yeah.
Discuss it.
Huh?
No, but
Someone makes a motion.
Yeah.
we discuss it.
I'll go ahead and give it a whirl. I want glasses on. Okay, so based on the additional information that I was provided, I believe that business confidentiality was properly applied to this record, the contract. had cases in the past where a business confidentiality was not provided, and we caught that and they had to provide the record. But in this case, it was provided. I feel it's it should be honored in that sense. So I believe that I make a motion that the appeal is denied. The records are properly classified under 305(1) and 2. We also have the business confidentiality stated under 309. So that is my motion.
And I will second that motion. I think this was been very hard for the committee to decide what to do on this, because we can see we see both sides of the case, but that's why we have to follow the code. So I would move, I would second your motion.
So we have a motion from Nova to deny the appeal and a second from Marie. Any discussion to the motion? So one comment that I would like to make is that we reviewed the records in camera. So are we saying that the redactions are correct?
Yeah, could we
Because
just say,
Attachments A and B,
just B is what I'd say.
just B.
Well, no,
A.
A needs to, but with the numbers. But I don't understand why the earlier redactions in the document, I just don't see.
Yeah, I didn't either.
you're referring to the
It was like Article 2 or something
The
like
very
that,
first
the first page.
The very first page, and then some under Article 2, and then and the attachment C's. I don't know why that's part of the
You're right.
strategy.
You're right.
But certainly attachment B would qualify under I think
But I guess the reason I bring it up is that I do think we need to note that we reviewed the records in camera. And you're essentially saying with your motion that there's a confidentiality agreement. We really don't know why they classified or they redacted that information.
I don't. I mean, whether I
You don't.
agree with it or not, I don't, but they have
Yeah.
a business confidentiality clause in there, and so I have to take it at
Right.
face
So then
value.
I would say that, I don't know if we say the redactions are correct or not, but they stand. And the parties can
Somebody wants to make a friendly amendment, but I don't know if I'm gonna
when
really-
we start parsing it like that.
Yeah, we don't know the reasons.
That they
Yeah.
redacted a certain way.
But I think it should be on the record that we couldn't figure out why.
Why?
Some of the
And oftentimes
redactions
we
were
don't know
redacted,
why.
Right.
I mean,
except for attachment B, it was clear, but yeah, I think we ought to go with just a
It's a clean.
blanket.
But a friendly amendment to your motion, I think it should be mentioned that we review the records.
Yeah,
Okay.
okay.
I'm good with that.
Committee, is that okay? We have a motion from Nova and a second from Marie. So further discussion. If there is, come on, we'll call vote. Ed? Aye. Mark? Aye. Nova? Aye. So the motion carries unanimously. So the order will be reviewed and signed by the chair and then distributed by the executive secretary to all the parties within 7 business days. And then either party may appeal to district court within 30 days of the date of the order. So thank you for your time and your patience today. It's been some hearings all day long. So
Thank you for your service. Thank you for your time.
Thank you.
The next item on the agenda is Adam Levesque talking and the state governor's office. It's hearing 2022-18. Neither of you like a drink.
Someone